Good morning, everyone. It is good to be here with all of you. And before I begin with our announcements today, I'd like to acknowledge some individuals who are here with me and some individuals who had a large hand in what we are about to announce today. Let me begin by acknowledging Deb Ryan, our district attorney here in Chester County, and we appreciate District Attorney Ryan and her team for their important work throughout this process and making an initial referral to our office to conduct this investigation. I don't see him here yet, but I really want to thank and acknowledge Delaware County District Attorney Jack Stolzheimer. I hope that's okay to do in Chester County. But Jack really did important work for us, both in terms of making this initial referral and doing some really important investigative work throughout the process. And so, on behalf of the Office of Attorney General, I truly want to thank Delaware County District Attorney Jack Stolzheimer. I also want to thank Berks County District Attorney John Adams, who's not here with us, but also referred this case to my office. And let me acknowledge and thank some really important folks who work in the Office of Attorney General. I'm proud to have them as my colleagues. Our Chief Deputy Attorney General, Becca Franz, who's with us today, who's just done incredible work on leading our environmental crime section, as well as Senior Deputy Attorney General Brian Coffey, Supervisory Special Agent Justice Bramley, and Special Agent Jeffrey Pratt. And of course, you've seen her standing to my right quite a bit over the years, our Executive Deputy Attorney General in charge of our Criminal Division, Jennifer Selber. So Jen, thank you very much for your work. I'm here today, here at the park, because Pennsylvanians have a right to clean air and pure water. It's a right that is enshrined in Article 1, Section 27 of our Commonwealth's Constitution. And we are one of just a handful of states that have constitutional guarantees to protect our environment. The case I'm here to announce today began through a referral by the district attorneys, as I said before, in Chester, Delaware, and Berks counties, and was submitted to the women and men of the 45th Statewide Investigating Grand Jury. Their diligence and their hard work has resulted in criminal charges that I'm here to announce today against Energy Transfer, the corporate successor to Sunoco, for illegal behavior that related to the construction of the Mariner East 2 pipeline that polluted our lakes, our rivers, and our water wells, and put Pennsylvania's safety at risk. Today, we're filing 48 comprehensive criminal charges against Energy Transfer. 45 of those charges are for illegally releasing industrial waste at 22 sites in 11 different counties across Pennsylvania. And it's important to note that while we're here in Chester County, this had a broad impact across our Commonwealth, from Washington and Westmoreland counties in western Pennsylvania to Blair and Huntington and Cumberland, all the way to Berks and Delaware, and of course right here in Chester County in southeastern Pennsylvania. 2 of these charges were able to be included because of information formally provided to our office yesterday by the Department of Environmental Protection. And I know that caused a brief but necessary postponement in our announcement in order to allow the Office of Attorney General to do our due diligence. Again, 2 of these charges were able to be included because of that information we received yesterday. There are 3 additional charges, including 1 felony for illegal and dangerous conduct statewide. Those charges include 1 charge for using unapproved additives in their drilling fluid, 1 charge for contaminating local water supplies, and 1 felony charge for willfully and consistently failing to report these releases to the Department of Environmental Protection. Look, when construction of Mariner East 2 began, DEP approved a process known as horizontal directional drilling for Energy Transfer to build this pipeline. This type of drilling requires high-pressure fluid, usually water mixed with bentonite clay and other additives, to keep the drill bit moving, to prevent the underground tunnel from collapsing, and to move rock and soil and replace it with the pipeline. Drilling like this is obviously complicated. An error can lead to unsafe fluid escaping, where it could contaminate local water supplies, pooling on the surface of local lakes and rivers. Every time those errors happen, the driller is required to report it under state regulation to the Department of Environmental Protection, so DEP can then take action. The grand jury heard testimony and saw evidence showing that releases of this fluid were frequent and damaging and largely unreported, and that hundreds of thousands of gallons of contaminated drilling fluid found its way out of the drill path into our waterways and into some Pennsylvania homes. The grand jury saw evidence that Energy Transfer knew about these releases and often chose not to report them to DEP until fluid emerged on the surface somewhere visible for all. And more than that, the grand jurors heard testimony and saw evidence that some contractors used, in addition to the bentonite, unapproved chemicals for this type of drilling, including chemicals that can irritate the skin and eyes. Under state regulation, DEP keeps an approved chemicals list, and unapproved chemicals must go through a review process to determine if they are needed. The grand jurors found records showing subcontractors sometimes ignored these procedures, and that Energy Transfer didn't adequately oversee those subcontractors, which allowed unapproved additives to be used. Understand that failure to oversee is not an error, but here in Pennsylvania, it is a crime. We're here today at Marsh Creek Lake, one of the many lakes and streams across Pennsylvania that the pipeline passed and polluted. Places we treasure, like Loyalhanna Lake and Raystown Lake. Look, these are places that we have a duty to protect and to conserve. They are part of our heritage here in the Commonwealth. It's where generations have come together to make memories, to fish and to boat and to hike with their families. In August of 2020, early estimates and some news reports from your outlets said that 8,100 gallons of fluid spilled into this lake right here behind me from a release. The grand jury heard testimony and have actually put that number significantly higher, between 21,000 and 28,000 gallons of contaminated fluid poured into this waterway. In total, more than 80,000 gallons of drilling fluid were lost in tributaries, on the surface, and in and around the lake during the construction of one segment of the pipeline between 2017 and 2020. Grand jurors saw records showing that it took more than 100 people in cleanup crews to contain this pollution and simply begin to restore this body of water. Many of these losses were never reported to DEP when they happened, despite the fact that Energy Transfer knew about those releases. This was a major incident, but understand it wasn't an isolated one. This happened all across the Commonwealth of Pennsylvania. And Pennsylvanians from impacted communities testified about thousands of gallons of drinking fluid being lost underground in groundwaters and in their groundwater in lakes and rivers and streams, and ultimately rendered them to be contaminated. The result? Pennsylvanians who lived next to construction, well, they suffered. And evidence presented showed the drinking water for a minimum of 150 families in the Commonwealth was contaminated. Take a look at these images around me. In a public park near one of the victims' homes, Rosemary from Media, who signed an easement for Energy Transfer to use a small part of her land. She testified to the grand jury that Energy Transfer claimed the incursion on her land would be, quote, minimal. Well, it was all underground and she wouldn't even notice it, she was told. Then they began to drill. She told the grand jurors that her water pressure dropped and a strange color sediment destroyed her shower, her dishwasher, and several toilets in her home. And then the sinkholes opened up. Her daughter then had to be hospitalized after drinking the contaminated water, despite assurances from Energy Transfer that the water was safe for her to drink. And it wasn't just Rosemary, understand? The grand jurors heard dozens of stories just like hers, from people like Karen in Glen Mills and families from Johnstown and Jeanette. What they said was consistent throughout their testimony, that Energy Transfer started drilling, the fluid started leaking, their drinking water was impacted, DEP wasn't notified, and nobody was held criminally accountable. These charges that we announced today begin to change that. If you believe that your drinking water or your property was impacted by these inadvertent returns, it's important that we in the Office of Attorney General know. Please contact our Environmental Crimes Section directly at 570-904-2643, or you can email us directly at environmentalcrimes@attorneygeneral.gov. Now listen, this isn't a lawsuit seeking penalties or fines. These are criminal charges for breaking Pennsylvania law. The Department of Environmental Protection has fined Energy Transfer for polluting our water dozens of times, yet the violations continued. So it's fair then for someone to ask, what does it mean to criminally charge a corporation in an environmental case under the laws of our Commonwealth? Well, first, unlike other crimes, state law does not require a company to intentionally or knowingly harm the environment in order for us to secure a conviction in these cases. There's actually a duty under the law to protect our air and water. And when companies harm these vital resources through negligence, it is a crime. Second, by charging Energy Transfer, we will force them to contend directly with criminal charges in a criminal courtroom here in Pennsylvania, and we will seek to hold them criminally accountable for their conduct. Third, we are sending a very clear message to other companies that we take our environmental laws and public health very, very seriously in the Office of Attorney General. And if they break our criminal laws, there will be consequences for that. Lastly, it allows us to keep investigating and uncovering all of the environmental crimes that happened here. We can shed light on them and ensure that the truth is told for each and every crime that was committed. And yet, under our laws, if convicted, this company, they'll be sentenced to fines. They'll be sentenced to fines. And I'm here to tell you, that's not enough. That's not enough. Corporations should not be treated leniently just because there's not a mugshot of Energy Transfer being arrested today. They should be held accountable to the fullest extent of the law. And that is what we are here to do, to apply the law without fear or without favor. As these charges make clear, there is a real wide gap between what our Constitution guarantees, clean air and pure water, and the reality for families and communities in the path of this pipeline. The oversight provided by DEP at times failed people. The laws we have to stop these crimes are simply not enough. We can't rely on these out-of-state companies to police themselves. Hell, they work for shareholders, not for us. It's the government's job to set the ground rules to protect us and to protect the public. And it's my job, it's our office's job, to uphold these laws. And so that's why I am calling once again for stronger laws to hold these companies accountable and to protect Pennsylvanians' health. I'm here to say that lawmakers need to do more. Lawmakers need to do more. And that's why we demand once again for DEP to toughen up the independent oversight we need them to provide on the industries that they regulate, and why we will pursue this case with everything we have in the Attorney General's office, led in the very capable hands by Becca Franz. Because when companies break the law and put public safety at risk, we have shown that we will take them on and work to hold them accountable. It's our duty, and we fundamentally believe that these charges will have an impact. For community members who are desperate to be heard, who have been crying out for a long time to be heard, I want you to know that we are listening and we hear you. We hear you. We know more must be done. We are here to take on this fight for you, and we are not done. To Energy Transfer and any other company out there, you are officially on notice. We are prepared to hold you criminally accountable when you break the laws here in the Commonwealth of Pennsylvania and harm the good people of the Keystone State. And with that, I'd be more than happy to do my best to answer your questions.
Thank you. Thank you, sir.
By the way, check your B-roll because about halfway through your presentation, a mature bald eagle flew behind all of you.
Okay. Let me see if the media has any questions. I appreciate y'all being here, but let's let the media ask their questions.
There have been numerous fines. There have been numerous slaps on the wrist for Sunoco over the past several years, yet they still have permits and everything that they need to do. Nothing's been pulled, nothing's been revoked.
Right.
Does this change anything, or do they just keep on working and keep doing what they're doing with another slap on the wrist with more fines?
Jim, I think respectfully that's a question for the Wolf administration and the DEP. The Office of Attorney General does not issue permits. We have no say over permits. Obviously, they are now learning this information as you are now learning this, and they'll make a determination as to what to do going forward with regard to permits. Deanna.
So then let's fast forward if they're found guilty.
Mm-hmm.
Then are they prevented from doing business in the state of Pennsylvania, or is it just business as usual, they write a check and they move on?
Again, that's a question for the Department of Environmental Protection who issue the permits. And I think you're asking the right question. I'm not in any way trying to blow off your question, but we don't issue permits. We had a similar case, Deanna, maybe 2 months ago, where we brought criminal charges in the largest wage theft case in the history of the United States here in Pennsylvania. It was a company in central Pennsylvania. One of the questions we got was, are they going to be able to continue to bid on work? A similar, I think, question to what you're asking as it relates to permits. And ultimately, that case, like this one, is up to the regulator, not to the law enforcement agency. So that's a question ultimately DEP needs to answer. No problem. Go ahead.
Well, then
follow.
moving on then, did your investigation uncover what DEP knew? And when you say that you're still continuing to investigate, are there possible allegations or investigations into what DEP knew?
Right.
And Energy Transfer, Sunoco, that's a company.
Mm-hmm.
That's a thing.
Right.
It's not like the thing polluted the river or the lake or the backyard or sent people to the hospital. So that means people had to know what was going on.
Right.
So why not charge those individual people, the people that knew, the people that sent emails, the people that saw this, the people that made promises
Right.
to these homeowners, rather than the company? Because those people,
Yeah.
you can physically place handcuffs on and bring them in if they violated the laws of Pennsylvania.
Yeah. First, let me just say, I'm limited in what I can say in response to your question to the four corners of this presentment, a presentment which I believe you have or you certainly have access to. And obviously, we charged everywhere we could possibly charge. As it relates to DEP, as I stated in my comments and as the presentment points out, in some cases, they were kept in the dark when it comes to the conduct of Energy Transfer. But again, what I could tell you is wherever we could make out criminal charges, we did. I can also tell you this is an ongoing investigation, and we're going to continue to do our work to make sure the truth is uncovered and that if crimes were committed, individuals or companies are held accountable.
And then regarding the people here, are we still investigating the people? Could there be criminal charges against individuals that work for these companies?
I think I answered that. We made out criminal charges wherever the evidence allowed that to occur.
Can you ask into the microphone, please? Sure.
Josh, why are you bringing charges now when the pipeline is almost completed?
Well, this investigation has been going on for some time. The grand jurors did their work diligently over the course of 2 years, 18 months. They completed their work, and upon completion of their work and receiving a judge's order to be able to speak about this publicly, we filed those charges today. So this took a lot of time. We worked diligently on it under the leadership of Becca Franz, and that is why we're here today.
And what do you say to union workers who might be losing their jobs because of this?
I don't know who's losing their job. I'm not sure I understand what you're...
Well, will this stop the pipeline?
Well, that's a question, as I said in response to Deanna Durante's question, you have to speak to DEP about. We don't issue permits here.
Okay.
Thank you.
Yeah, thank you.
Hi. So, have you had discussions with the Wolf administration already about any of these charges or the investigation? And if so, can you tell us, characterize them in any way?
I have not.
How about DEP?
Well, DEP were involved, some at DEP were involved in testifying before the grand jury. You see that information contained in the presentment. Beyond that, I've had no conversations with the Wolf administration about this case. Indeed, it wasn't a matter for public discussion until just a few moments ago.
So, and you mentioned that you can't charge individuals. Are you, what are you?
I didn't say that.
Oh,
I said
okay. You don't have the evidence to charge
I
individuals.
said that we issued criminal charges where the evidence allowed.
So, what are you mentioned something earlier about the legislature. What do you want the legislature to do?
I think, I believe it was Deanna who asked this question. If not, it might have been Jim. The question about the fines. I believe the fines need to be far more significant than what the law allows. I think the penalties need to be far stiffer. I'm not the lawmaker, I'm the law enforcer. But I think lawmakers, if they're serious about meeting their the constitutional requirement of Article 1, Section 27, need to significantly increase penalties under state law for these types of crimes.
And right now, I mean, it might be in this 69 pages on it, forgive me, but how much, what would be the fine? What, is there a range of fines at this point, given what these charges are? Can you give us a sense of what that would be?
It's hard for me to put a number around that for the following reasons. We have to have a trial. We have to secure convictions on each of these counts. And then ultimately a judge would determine what that sentence or what that fine would be. We're going to put everything we have into securing a conviction in this case and doing everything we can to bring justice under the laws as they exist here in the Commonwealth. But again, I think it's critically important that lawmakers hear our pleas to increase penalties and to improve accountability in these types of situations.
So you're ready to go to trial? You're not going to settle this or?
Oh, we're absolutely ready to go to trial. Anything else, guys?
Yeah, I'm just trying to follow up on that question because it's kind of vague, the difference between the DEP penalty and what a court might ultimately decide on, a jury might decide on. Are you looking at fines in the millions or tens of millions? Are you hoping for?
It's not vague at all. DEP is the regulator.
Right.
They issue fines when they feel as though their regulations have been violated. They can speak for themselves on that.
Right.
We file criminal charges,
Right.
and that's what we did here. 48 criminal charges to be exact. The sanction for conviction under one of those criminal charges is a fine. What I've said in response to the gentlelady's question a moment ago is I believe the penalties should be far stiffer than what they are.
Okay, so ultimately it will come down to existing state statutes, what penalty they face.
We're
not-
charging under existing state statutes.
okay.
Certainly, I hope the legislature would amend those statutes and stiffen the penalties, but that wouldn't be applied retroactively. That would be prospectively.
So then what is the real difference between these actions and what DEP would?
We filed
would do on
criminal
its own?
charges. This company now has to appear in a criminal court of law. They have to answer for their crimes in Pennsylvania. These are serious crimes. I wish the penalties were stiffer, but make no mistake, this is a company that is now facing 48 criminal charges, including a felony here in the Commonwealth of Pennsylvania, and we're not done. Our investigation is continuing.
Thank you.
Okay? Thanks, everybody. Oh, sorry.
Just really quick. So if they're convicted of felonies, they could pay theoretically, and this is hypothetical, If they were convicted, they could pay the fines and continue work on the pipelines.
That's up to the Department of Environmental Protection to determine.
But it's a possibility. That's
I
something-
really can't, and Jim, I really appreciate your question. I'm not trying to give you a hard time. I can't speak for the DEP. They will ultimately make that determination. The Office of Attorney General, the Office of District Attorney, has no say over permits. That'll be up to DEP.
And at this point, you cannot rule out the possibility that there could be criminal charges against individuals.
I am saying that my comments today are based on the four corners of this presentment. We made out every single criminal charge we could make out based on the evidence that we have, and I can also tell you that our investigation is ongoing.
But can you rule out the possibility of criminal
Jim,
charges against
I
individuals?
answered your question. Okay? Thank you all very much. Sorry, Dan.
Few more. So back in 2018, the Chester County District Attorney, the former District Attorney, began an investigation into what was going on Lisa Drive, the sinkholes with the properties there. Then, in response to that, Energy Transfer told us that they deny any wrongdoing. They take issue with the factual inconsistencies with what was said in that news conference back in 2018. Then 4 months later, those property owners that were the subject of the investigation sold their property to Energy Transfer, were unable to talk about anything from that, why they sold, any kind of agreement with Energy Transfer. Did NDAs impact this investigation? Did they hamper the investigation? And what do you want to see happen when it comes to NDAs with these cases as well as other cases in the Commonwealth in the future?
Let me make a broad statement. I'm going to ask Becca to speak specifically about that. I've been very clear, particularly coming out of our investigation into abuse within the Catholic Church, that NDAs should not be used to shield people from speaking their truth to law enforcement. And indeed, new laws have been passed in Pennsylvania to make clear that non-disclosure agreements can't be used to shield communication with law enforcement. As it relates to those on Lisa Drive, I'm going to let you address it if you'd like.
Sure. I think you'll see that Lisa Drive is a location where there are charges filed for. So I think beyond that, you know, the presentment speaks for itself. I would certainly echo the Attorney General's comments that non-disclosure orders are a hindrance to criminal investigations and prosecutions. Yeah, I think that's
Great.
all we can say.
Thank you, everybody.